management lawyer here with Anderson Lloyd Lawyers in Queenstown. I work quite closely with Marie Baker, who has been heavily involved acting for clients opposing both the monorail and the tunnel proceedings to date. So I'm just here to give you a little bit of an overview about the legal process, the steps going forward and the challenges that you might face. So at the moment the Department of Conservation is writing its recommending report on the concession application for the tunnel, and once they've finished writing that report, then the applicant, NDL, will get an opportunity to comment on that report. They get to do that prior to its public release, and as people of the community, you don't get a chance to see that report until it is publicly released, and there's no way of seeing a copy of that report or MDL's comments until they are publicly released. Once the report has been completed, the recommending report, it then goes to the Minister or the Director General of Conservation on the Minister's behalf to make a determination. It's important to note that while the Minister or the Director General, they can either choose to accept or decline the report from the hearings panel, and whether they there have been cases where the hearings panel has recommended, say, that a concession application be declined, and then the Minister or the Director General have decided that no, they disagree with that recommendation and they have chosen the alternative and said that the concession should be granted. And there's also other cases where they have done the vice versa. So it's important to note that whatever the hearing panel's recommendation is, that doesn't necessarily mean that the Minister or the Director General will accept that. But generally speaking, I guess there's more cases where they have, which, yeah. If the hearings panel recommends that the concession for the tunnel be granted and the Minister or Director General accept that recommendation, then the next legal avenue for you to follow is judicial review, which involves High Court proceedings. There's no set time frame for when you need to undertake judicial review or go to the High Court. However, I guess there's a presumption that you should do that as soon as possible in order to preserve the status quo. So if you, for example, if you decided to wait a year or 2 years before you undertook those judicial review proceedings, their MDL might have started some of the works, and that of course would act against you in terms of trying to get that judicial review or the decision, a recommendation sent back to the hearings panel to reconsider. So what is judicial review? And I guess a lot of people here will be wondering what are the grounds for that. So generally speaking, that for judicial review, you can go to appeal it in terms of the hearings panel may have failed to take into account a relevant consideration, or they might have taken into account some irrelevant considerations that shouldn't have been taken into account as part of their decision. Or there could be an error of law, such as an incorrect interpretation of a management plan or the Conservation Act, the National Parks Act, or National Park General Policy. We can't really give you any advice in terms of what the points of judicial review should be until such time as we see the decision on that. But once we have the recommending or the report from the Minister, then that's when you can work out what the grounds for judicial review would be. The important thing here to note is that initiating judicial review proceedings in the High Court is a serious and involved process, and unfortunately it costs money and you need to involve lawyers. As part of that process, you lodge a statement of claim which sets out the matters that, such as the parties, the subject matter, the relief that you'd want, and the decision. There's a court filing fee of $1,329, so that's just for lodging the document with the court, and from there the costs unfortunately get higher. A complex judicial review process can cost you anywhere between $60,000 to $120,000 in both, which includes your expert witness fees, legal fees, as well as court fees. And because you're an incorporated society, that does give the group some protection in terms of costs being claimed against you if you are unsuccessful, provided that the case is run in a well-constructed and has merit and there hasn't been an abuse process. If you lose in the High Court, then the court automatically awards costs against the unsuccessful party. And if you had a 3-day hearing for that, it's likely that the court could award costs in the vicinity of about $20,000 to $40,000. So that's a risk that you really need to be aware of. And as Lloyd said earlier, this is an expensive process. And if you're going to go down this, keep going with this path, then you need to be aware of those costs so that you know the steps along the way and what that bigger picture is going to be. It is possible that the court may require that an incorporated society provide security of costs, which would mean you'd have to fork out some of the costs up front, and MDL may want that as part of this process. That's it?
Yep.
So those are the basic process going forward in terms of judicial review, and I'll take any questions later.